So I will add the whole panel, so you know most of them already from the previous session. But first of all, I would like to also leave the floor to the moderator of this panel, Cecilia Magnusson Sjöberg, who is Professor of Law and Information Technology at the Swedish Law and Informatics Research Institute. She has many years of experience in research projects about the interplay between law and modern information communication technologies, in particular about privacy protection and legal system design and management. And in the meantime, I will fetch the rest of the panel. Okay, so I think we are complete. So I leave the floor to you, Cecilia.
Thank you very much. You can see me and you can hear me?
Perfectly, yes.
Super, thank you. Well, thank you very much for the invitation, for having me in this rather innovative, almost ending of the conference day. It has been a full day of very interesting and challenging presentations and discussions. So there should be treats for everyone, definitely. So my task is to do some wrapping up, definitely not summing up, and I will not close the conference either, but some wrapping I will provide you. And as earlier pointed at, there is this innovative ambition in this, the design, the outline of this conference, and that implies, with regard to my contribution, that I will share with you some reflections at what may be referred to as a kind of meta level about what do we focus on in terms of law and IT from the point of view of a law school, of law faculty, Department of Law, that similar organizations. So what I've been asked to do is to a few of future-oriented reflections, and also to together with you come up with some advice towards the younger researchers. So we'll come back to that. And I'm really happy to have such an knowledgeable panel, and you've been active before during this day, so maybe I should just say a very few words about where I come from. And I come from Stockholm University, as been introduced, the Faculty of Law, the Swedish Law and Informatics Research Institute. And just to give you a historical perspective about what's new, what's old, in 1968, the Swedish Working Party for EDP, in terms of electronic data processing, Working Party was established at the law faculty. And in 1981, we began teaching law students about law and IT. And what we do right now is that we provide a mandatory 4 weeks course in law and IT. We have elected courses, we have exam papers, conventional papers, but I think what is demanding and challenging is in particular the mandatory course, considering that we sign up for about, or we have about 220, 250 students studying each semester at the university. So it's quite a lot of students to exam, etc., and everything that we do with students. I will not place an emphasis on today's major topic in terms of anonymization, pseudonymizations, or the borderline challenging aspects of the interaction of law and ICT in the context of personal data processing. Considering that this is not a detective story, I will reveal 3 major questions that I would like to hear your opinion about. We'll come back to them. But one has to do with integration versus concentration. I'll come back to what I mean by that just shortly. And then also to what extent, if at all, there is a quest for legal competence, technological competence working in this area. And then to the extent time allows, also discuss what will be our advice to our younger researchers. And you've been meeting quite a few of them, or not quite a few, but a few of them earlier today. I think, though, that GDPR and associated legal frameworks is an excellent example of a topic area that we need to relate to if we take up on our role as a lecturer, teachers, researchers, etc. GDPR has it all in terms of having provisions. We have the recitals, we have the provisions, addressing legal issues, regulating legal issues that basically belong to traditional topic areas. We have there are public law provisions, private oriented provisions, liabilities, the differences between public law, private law. I mean, GDPR, there are so many areas that are covered that one might start thinking about, is it high time, is it time for us to kind of export what we're doing within the framework of the law and IT topic areas? And do we even, I mean, where do we stand right now in terms, do we have how shall I say, do we have reached a point when there is no reason to stick together, but rather to export our understanding of the interplay between law and IT? I mean, there is no label, there is no international global label in terms of this is a contract law, this is copyright law, but it's a very fragmented, but then again also very comprehensive interaction between law and IT. The question, I mean, at our law faculty and also at other law faculties in the Nordic countries, there is this key question: should we, within our field, and I expect that it looks quite different. I mean, you come from different countries and different systems, but is it time to do this export, or shall we stick together in Rechtsinformatik and law and IT, ICT law, different labels? Maybe copyright doesn't need to be treated within the area of law and IT. Maybe copyright issues with regard to computer code or computer programs should be taken care of by the traditional areas. There was a time when it was possible to be in command of, in particular, almost everything, every topic areas that have legal implications. But today it's all. So from a strategic point of view, would you argue that maybe we reached the stage of integration, or should we stick to develop our research institutes like the one that we are so impressively in getting to know more now? And also from a collegial point of view, would we be welcomed at the traditional? Will the traditional area topics representatives accept us? Is it time for an export, or should we rather concentrate and become even more experts within our very specific research institutes, for instance? So if you get my very brief presentation of state of arts, what would be your instant reaction to the integration in conventional areas, topics, or concentration in order to further deepen our understanding of the interplay between law and IT? And just one more thing adding to the picture, it has to do with that one major track within this topic area is IT law in terms of substantive law issues, how to apply legal rules in digital environments. That's one kind of major track. But then we have also the more methodological one where we discuss legal system management, how to proactively embed law into different kinds of system design, development, implementation. What do you think? I don't have a specific order, so first one who grabs the screen wins. Did you get what I was getting at, the integration concentration? Yes.
Go ahead, Michael.
Sure, I have some initial reactions. I think that's really, yeah, those are really challenging questions. I think one thing that we should be focusing on more going forwards is thinking maybe from a teaching point of view, but also in terms of building researchers, teaching boundary skills and bridging skills. One thing I think that we are really good at in the field of IT law and need to get even better at is teaching students to deal with quite complex technical issues, being able to deal with other disciplines and to be able to bridge and say, I can distill those technical concepts, I can extract the things that are relevant for legal understanding, and I can also draw upon and collaborate with more traditional legal scholars in areas, you know, of say tort, where it gets, you know, will get very confusing and very regional and different per jurisdiction, and be a translator there. One challenge we'll always come across, though, I think, and it's an area that is a challenge I think we see in those more traditional domains. There's a tendency for single authorship compared to in tech law, I think. There's a tendency to value people who are kind of lone wolves working alone on a monograph for many, many years, whereas I think in tech law, we've always had the collaborative, the respect when we see a paper and it's got a lot of people on. We say that could be a really great paper, whereas I think it can confuse people in other legal disciplines sometimes as to why there might be those people there. So there's a bit of tension that we need to resolve in those traditional disciplines. Similarly, you know, we have a very progressive approach to open access. I was just talking in our faculty recently, and you know, people are saying, oh, but things that open access requirements are coming on us. We don't really know. We can't publish in the prestigious places, or it might restrict us. Thinking, wow, I haven't seen a journal with an embargo in technology law really for a very long time. Maybe I don't know. You can't even think of any that have them right now on a preprint embargo. And so we have a lot of things that we could export, practices that I think we should export and say, you know, there's time to update the rest of the field. But I think the last thing I want to ask is, you know, if we want to become a skills zone, to say, actually, one thing we're really proud of is teaching these boundary skills, which parts of law, substantive IT law, do stay in IT law, and do they ever graduate? So I'm thinking of copyright. You know, copyright is in you know, obviously it's got a very different history and different area of scholarship, but things like intermediary liability often fall much more within IT law and get much more you know, held as the role of intermediaries. Similar with data law. Information law obviously has freedom of information components, public information components, but of course still the data protection law side comes more in IT law. And so I think navigating how we spread those substantive issues across domains and where the cutoff point is and where the skills exist will require us to both reconfigure our own practice and research, but also to convince the more traditional legal fields that they may need some help with these topics.
Thank you so much. And to me, it strikes as if it kind of common, I wouldn't necessarily say problems, but contextual starting points. And sometimes you stay in your own environment and you think that it's so exceptional, different. But when I listen to you in your comments, I say, well, that's very much the way in which we reason. But please, some more comments. Integration versus concentration.
Maybe I can add a little bit from my own experience from the University Ghent, where I'm affiliated with. There we had quite maybe a bit special, let's say, approach to address issues related to privacy. And we have kind of an interdisciplinary platform, which is tackling issues related to health data from a 3 different perspectives of health law, health privacy law, and also medical ethics. And I find it very, let's say, yeah, it's very helpful in a sense that we can really take advantage of expertise from different colleagues and still focus on yeah, very specific topic of health and health data. And just listening to some of the talks today, that, for example, the case of Havasupai, I just wanted to immediately like refer to, for example, some other safeguards that they are in place, but they are not necessarily coming from data protection regulation, because there we are also dealing with issues with regulation of, for example, research with human subjects and, for example, necessity for ethics approvals and so on. So in a sense that sometimes it's really necessary to add different expertise. Sometimes we can find them still inside a law school. But in our case, for example, we brought together expertise from 3 different faculties of law, medicine, and philosophy, and it was very enriching. And related to that, also another experience that I also started a new course this year on data ethics, which also received very well also by law students. And it was very interesting to see that they wanted more. I mean, we focus a lot on legal framework, on data protection regulation, on GDPR, but we sometimes will reach the limits of the regulation, and students wanted also to discuss that more. So I think that was all. I think they were positive experiences.
Following up a bit on the ethical aspects, what we experience is that to an increasing amount, not least in the context of European Union projects, we have these internal and external advisory boards, and then it's kind of a tag in terms of ethical and legal, or legal and ethical. And at our faculty, we're somewhat struggling with the ethical perspective, because it's not just a tag. This is science in its own specific topic. How do you have?
Yeah, I agree. I think that this is more and more it's requirements from the, for example, European Commission. If you have an EU project, and if you are dealing with processing, for example, larger scale of data or sensitive data, it's more often you've been required to appoint an external ethics advisor. And of course, sometimes, yeah, people are of course free in choosing these ethics advisors, and they have different profiles. They are not necessarily all like trained in ethics, for example. Sometimes they just have, for example, some expertise as well. I mean, from their own, they're science-based people, but it's still they have also some expertise in the ethics related issues, or they're sensitive about that. So I think that the idea is that, yeah, to have a kind of extra monitoring in a sense on making sure that the data related issues are being dealt well and adequately. But of course, it's not always, the line is not very clear. I think the idea is that still legal aspects should be monitored with, for example, data protection officers of the hosting institution, and then the rest of the issues to be left to be kind of monitored by the ethics advisors. How well this is working or functioning, I think it's still open to the questions.
Thank you. And Nadezhda, experiences and thoughts about integration versus concentration in the context of this interplay between law and ICT?
So my reflection is based on my observation of the experiences of my department. We have recently gone through a system of major reorganization, partially with the purpose to basically revive the relevance of the research in the law school. And what I observe is that basically the research in every traditional department of the law school is now infused with law and technology questions, as basically every aspect of our life and every area, basically every aspect of our life now is infused with technology. So in the labor law department, we have people studying technology and labor law think of Uber, exploitation of the delivery system workers and such. Civil lawyers study, basically they find their own angles and entry points into law and technology. So I think it is inevitable that there will be some, let's put it this way, decentralization of the study of law and technology, or IT law. At the same time, I think, well, in terms of decentralization, or better said, as Michael put it very aptly, building bridges, it's, for instance, speaking from the perspective of the law, of data protection law, it's impossible to be a practicing lawyer now somewhere in a company, suppose at council, without basic knowledge of data protection law. And so in practice, the popularity of data protection courses at our department is through the roof. So I believe we had to create 2 additional courses just to cater for the demand. At the same time, I think that basically the area of law and technology, or IT law, as you put it, well, I would say law and technology broadly, it has its own core that other domains do not touch, such as just the general patterns and theories of regulating technology, or the interaction between law and technology. For instance, one of the top scholars in our field, Mirai Hildebrand, she's currently studying the impact of code on law as a phenomenon, let's put it this way, rather than law in a particular area. So we definitely have our core that we can keep, that the other departments will not touch. At the same time, I also know from experience that colleagues from my department are welcome at all sorts of departments. For instance, one has recently started at the criminal law department with the background in privacy law. So, and at the same time, again, looking at building bridges, perhaps if we keep other areas of law in mind, again, as a data protection scholar, perhaps our eyes will be open more at the fact that there are other areas of law to resolve the issues that happen by means of IT and the internet, and not only data protection.
Very interesting, and I recognize also the rapid growth with regard to experts on data protection and many other topic areas. Suddenly there were experts everywhere, experts on IT. But that I also agree with the fact that GDPR has been a fantastic tool in terms of bringing the legal issues in digital environments on top of the agenda. So it has been good from that point of view. And also what I can hear is the fact that we should but that it can be argued that there are certain advantages when it comes to studying legal infrastructures and the impact by ICT, that we do have a core of questions that probably our colleagues will not dig into because they have another profile. I mean, we could just look at AI approaches, artificial intelligence, and the fact that some of us that were present also during the old school and of expert systems knowledge engineers, etc., have some experiences that could very well be built into modern approaches. Connected to what we've been discussing so far, I would say that the question of, if I put it like the legal tech approach, or the fact that, well, to what extent, if at all, do we, I'm not talking primarily about the students, but we as scholars, teachers, do we need to be in command of ICT? I mean, there was a time when it was kind of possible to understand and actually do work without do technical work. Could be information standards, could be coding some algorithms. The technology, well, to some extent, it might have been more easy for non-techies to work with technology. But what we see now within the framework of large student groups is that there are an increasing number of technical, very skilled students. And we also see the legal tech associations for younger lawyers, legal tech in general. And we had also very interesting presentations today about hash functions and for instance, and coding in general, information standards, designing development schemas, and take the hash function and the fingerprints and the PKI infrastructures. To what extent do we, should we, could we, ought we educate our students to go a bit beyond understanding the EIRA's regulation about electronic signatures, for instance? What about other understandings of how to use cryptography, the public, the private key, etc.? Is that a special branch within the broad area of IT law, or should we actually already, well, give our students some basic IT understanding as a compulsory, or as a part of the fundamental legal education, because we are living in a society where it might be needed for the understanding of what is adequate technical organizational measures in the GDPR, for instance. How do we approach issues of profiling and pseudonymization? And Article 22, for instance, automatic decision making. So to what extent do you see today that the legal tech aspects are covered? Is there a need to increase, enlarge, or, well, do you have any reflections concerning the IT students being in command of IT to some extent? Please, who would like to begin?
I have a bit of a reflection. I think what we need as to be producing as technology law scholars from our students is not a monoculture of one type of student, but we actually need to produce a wide variety. And so what I mean by this is that some people, so I'm more of a policy scholar. I work with some of the hands-on areas of technology and try to interpret some of the kind of the cutting edge and the technical aspects of it and interpret it back into policy and law and look at tensions there. That's not for everyone. I sit at that side. When I educate, I teach people about the fundamental protocols underlying the internet and try to give them skills that can help them realize they too could understand new technologies as they come out, because there's no use teaching them old technologies. We need to give them the skills to grapple with things as they come out and not be afraid of that. But that's only one type of person that we need. We also need people who are very doctrinal and understand quite deeply the legal texts, and in relation to many other, I think, as Nadia was saying, more traditional areas of law, and understanding what lessons can be learned from there, so they don't imagine that they're going off into, you only need to read data protection law and nothing else. Like, no, it's actually, when this plays out in reality, lots of other laws will be intersecting with it, and lots of other fundamental rights, and we'll need to understand them. So I think we somehow need to work out an educational schema that outputs all of these, and whether that's through allowing streaming. So if people want to go more into technology policy, and actually I think policy is a key word there, because what we do a lot in technology law is teach policy. We teach gray areas, we teach normatively how it could be, ask people to work with cases from different countries where they might not be applicable in their home jurisdiction, because they give guidance on how things and areas might develop. And so those kind of skills, are one set of skills that we need to be producing, but they're not the only ones. And so structurally, how do we understand the roles in society that we input out from technology law? And then how do we work backwards to make sure those variety of courses, those variety of pathways are there, and students can say, oh, I actually really like the technology side of it. I want to be a translator. Or I really like, the nitty-gritty doctrinal, traditional legal research side as applied to technology. I need to do that, and I want to know how to work with those translators back and forwards, in a team. And I don't know how we quite get there, because it sounds quite labor intensive. But I mean, somewhere like Tilburg Law School, where Nadia is, have a lot of staff and work on this in a variety of angles. Whereas at UCL, where I am, we don't have large technology law streams, so we can't divvy it out in that kind of way. So it will depend a lot on the scale. And obviously, I presume in Sweden and many Nordic countries, this is also very well developed because of your history in this area.
But then again, it's a true challenge. The fact that we have quite a large number of students, over more than 200 per semester, it provides constraints in terms of lab environments. I mean, we would need more. It's difficult to theoretically talk about IT law. You need to show, you need to do And that's something that we have always been struggling with. It's been easier, I would say, to teach legal information retrieval, because that's different. Thank you very much, Michael. Any other comments about the legal tech approach?
I think I would agree with Michael here. We need, let's say, as it is the case with law and technology scholars, we need different types of scholars, and we need different types of IT lawyers. Let's say some people are exceptionally good in translating the technical difficulties to other legal minds, who then end up reproducing basically the way how the facts were portrayed in this original paper, in their papers, as the truth about how technology works, without really understanding it themselves. So some people are better with building or playing a liaison between technology and law, and some people are not made for that at all. And I think definitely in terms of like pragmatic solutions, it is also important to avoid the broken phone situations, to prepare at least some to understand technology, and perhaps offer an elective course, a small course for people for students to really learn what, for instance, the neural net is, or what deep learning means exactly.
Thank you. Yeah, and Masha.
Yeah, maybe also add from my experience in Ghent that, well, I think the idea was that, again, just more providing and offering some electives for those students that who are showing interest in these topics, more in a master or LLM level. But yeah, I wonder if that's enough, just considering that how ICT is really impacting all these different let's say aspects or contexts of life. So I think the plan is that we will be having soon let's say mandatory bachelor course for legal tech. And I think that it's been offered with my colleagues, Professor Eva Levens, and I think that that's, I find it a good approach as well, because in a sense that you kind of showing the importance of the topic for all our students, rather than just saying that, yeah, this is only for those that were interested, and they can just be more like attracted to some of these electives, or like some more like a specialized LLMs.
Wherever has the time to do these mandatory courses, it's huge. I was wondering, I'd one more quick thing, which is that there's a myth of the digital native, right? We think that students who are coming in when they're 18 now, at least in most European systems, I guess, rather than in the US where legal education happens a lot later, that they understand technology because they're young. This is not true. They've grown up in a world of platforms where they've been spoon-fed particular kinds of technology, and they, I have to go in my course. I have to teach them what the internet protocol is, how actually the internet works, the network of networks, roughly moving on from these like base foundational infrastructural levels, which not only like some of them have not heard of, like none of them have heard of or grappled with for this, these areas of the internet, because it's so hidden from them now. Everything's so seamless. And I suppose, I guess you could talk to this a lot, Cecilia, like, when you were in the first wave of expert systems, as one of Frank Pallas writes in the question and answers, many people were building expert systems, formulating database queries in legal academia too, in a different way. I think people were aware of those roots a lot more, and that was just unquestioned that those basic building blocks were there. And so we do have to maybe put some labor and effort into replacing what platforms have taken away.
That's so important. I remember those days when teaching Boolean algebra and recall and precision, and then there was just Google, and everyone was Googling without, being that aware of underlying algorithms, etc. Time is flying, but what advice would you give to one of your younger researchers? What do you have an advice? Of course you have. You're all experienced and skilled. So what would you, I mean, we all receive email messages, don't we? Hi, Cecilia, I'm going to study this IDLaw. I'm going to write my exam thesis. What should I write about? But there was this time that it was not only on a daily basis, but almost everyone wanted to write the thesis about GDPR. Of course, still many are interested. But what would you say? What would you respond to? What would be your reply if I would ask you? What would be your advice? Not necessarily just writing an exam paper, but if advice when it comes to future career within the area of, what shall we say, law and informatics.
If I may, let's say, the advice that I give to my PhD students, and what I think was one of the biggest lessons I learned from my PhD supervisor, was to and this is really on the basically procedural level of doing a PhD and being a young researcher at the beginning of your career, is to have trust in your ideas and not be scared to present them in papers and to others.
To be intellectually brave, right?
Yes, to go out there and basically what you think, just expose it, put it up for bashing.
I think there's two related things. Sorry.
We have 49 participants, so hopefully if you listen to that advice. Some more advice?
I think one thing that's one part that relates, I think, to Nadia's point there is, and it relates, I think, to the questions about traditional law, is to challenge orthodoxy sometimes, especially in technology law. There's a lot of people who have got very fancy titles who have no idea what they're talking about when they wade into IT law. And that's, just to be aware of that, like, don't be too deferent, kind of, you've got to think on your own. But another more practical social area is to make friends with your peers in, say, computer science, because the people who will teach you about those, if you want to be a liaison in that way between those two areas, are colleagues, fellow undergraduates in computer science, fellow graduates, fellow PhD students, who you can work together and collaborate with. Because if you follow the kind of top-down approach, we might not have set up the training that they really need, right? Everyone gets to where they are in IT law in a very haphazard way. We haven't got a great path trodden yet to make all these fantastic variety that we see today. And if you ask people, how did you get into this? It's often through a big mishmash of coincidence and an interest, and they've got to create that mishmash for themselves. And that does mean, really collaborating with your peers, and together you can understand things that your more seniors will not be able to.
And thank you. And furthermore, that could be a way of compensating for your colleagues at the law department that think you are doing some very weird things that is hardly within the legal sphere, because that shouldn't, I mean, that's also something sociology wise, that is not always easy to be that strange person doing this tech things.
Yeah, because you need to be thanked, and you need to be celebrated with your own work, and people will do once you find your community if it is doing interesting things. And it's just knowing that's there. We try to make, I think, IT law is a very friendly place internationally compared to, I think, other areas of law, and so we try to make it a bit, but people have to make their own social circles, unfortunately, to brave their own institutional because it's not going to be easy. And maybe telling them you might end up somewhere where you're basically bullied. So that's a sad truth in many law departments as a tech law person.
Unfortunately, I know what you're talking about, and we're working on it. But that is a challenge, definitely. So please.
Maybe the final one is just just strangely enough, some of the topics related to IT law just tend to be immediately become a hot topic, and so it was sometimes many people just rush to write something immediately on that. And sometimes it's just intimidating for some researchers, because they start to think that, well, everybody's writing on that, so either I have to write something fast and quick on it, or I just should leave the topic. And this is often, it's not really true. And I think that as a young researcher, that could be a challenge as well. I think I would say that just don't get intimidated with this rush to some of the hot topics when it comes to ICT law.
Have you, thank you, have you also experienced an interest quest from tech students to teach, to understand more about IT law. I mean, IT law for IT professionals. We see a growing demand or interest
Yeah,
in
definitely.
law for ITs.
I think they immediately feel that they need to understand at least the basics. But of course, it's not always, the setting is not right to have that, let's say, a dialogue between the tech experts and lawyers. So it's, yeah, but I think that it's evident that it's a kind of, there's a need to this collaboration as well, and to at least understanding the basic concepts.
I think time is out. We're at, well, maybe we have 2 minutes left, but
there's a question in the chat for someone to put their hand up, and maybe they want to ask a question, but I don't know how to do that.
No, I don't. Catherine, maybe she could help.
I'm allowing Yelena to talk if she feels like it still, as the hand was raised for quite a while now.
Oh.
So we're listening.
Okay, so maybe this was a mistake. So let's see if Yelena says something.
Oh, maybe not. Okay.
I don't think so. Nicholas speaking here now. Mm-hmm.
Thank you very much, panel. I really appreciated your comments and your willingness to discuss. Thank you so much.
Thank you as well.
Thank you so much, Cecilia. Thank you to all our panelists. It was really a pleasure to have you here and to listen to you. And it was a very broad topic at the end. So I really appreciated the overall perspective of this.